Good, same.
Good afternoon. I'd like to call this meeting to order of the Plain Township Board of Zoning Appeals for September 5th, 2018. Roll call vote, please. Roll call.
Mr. Sutton.
Here.
Mr. Beck. Mr. Carpenter. Mr. Kozlowski.
Here.
Mr. Reichel.
Present.
And Mr. Schultz.
Here. All right, I'd like to introduce the members of the Board of Zoning Appeals. My name is Bob Souls. I am the chairman. To my right is Tim Reichel. He is the vice chairman. Next to me is Demetrius Pusilides, who is the secretary. And also here tonight is Jeff Sutton. Has everyone had an opportunity to review the agenda for tonight's meeting? Any changes to the agenda? If not, the agenda will stand as presented. Relative to a statement of duties, we will not read the statement of duties, but it is available for anyone to read in the back. Has everyone had an opportunity to review the minutes for August 1st meeting? I hear a motion to approve those minutes.
So moved.
Have a second?
Second.
Roll call vote, please.
Mr. Sutton.
Yes.
Mr. Kozlowski.
Yes.
Mr. Reichel. Mr. Schultz.
Yes. All right, we have new business before the board this evening. There's appeal number 1271-18, that's Emerson Foltz, and appeal number 1272-18, Denise Armitage. We did receive comments from the fire department, and I'll read those into the record. With respect to appeal number 1271-18, Emerson Foltz, 1005 Pittsburgh Road, Northwest Canton, Ohio 44720. The request for variance has been reviewed, and there are no recommendations or suggestions regarding the appeal. With respect to appeal number 1272-18, Denise Armitage, 7690 Bucknell Circle, Northwest Canton, Ohio 44720. The request for a variance has been reviewed, and there are no recommendations or suggestions regarding the appeal. All right, the first appeal this evening is appeal number 1271-18. That is appeal number 1271-18, Emerson Foltz. And that is 1005 Pittsburgh Road, Northwest Canton, Ohio. Applicant requested variance to place a 1,728 square foot accessory building located at 1005 Pittsburgh Road, Northwest Canton, Ohio 44720. That's parcel number 55-01403, section 602.5, paren A, paren 2, accessory uses, buildings, and structures. 1,228 square foot size variance is required, 500 square foot permitted, 1,728 square foot requested. Before we move on to that appeal, if anyone is going to speak before the board this evening, I please ask that you please stand and raise your right hand. Please stand and raise your right hand. Do you swear or affirm the information you're about to present is true and accurate to the best of your knowledge and belief?
Yes.
All right, is there someone here to present the appeal on behalf of Emerson Foltz?
There you go. Emerson Foltz, Brian Foltz's son.
Would you state your name and address, sir?
Emerson W. Foltz, 1005 Pittsburgh Avenue, Northwest, North Canton, Ohio, 44720.
And with you, yes? Sir?
Brian Foltz,
Brian.
1010 East Maple Street, North Canton, Ohio.
You could please go ahead and state the basis for your appeal before the board this evening.
Well, the size of the building is needed for put my stuff in that's been parked outside for years, like you might see. There's a camping trailer in the front yard. I got 3 Model T touring cars, antique cars, Model A antique car, and plus my trailer and things like that, utility trailers and so much stuff sitting outside. That's why I wanted the building this size. It's numerous antique furniture I got, and property and surrounded by commercial property, vehicles could be moved and stored in the driveway, and a building, I could have I have to use rental places to try to get rid of them in the wintertime. All this is a problem, and then stuff is damaged, my neighbor sometimes, small stuff stolen. But I can't remember, it's been so long ago, that stuff's been out for quite a while. So it's hard and expensive to get, get insurance and stuff, this stuff sitting outside, they want it garaged all the time. But I got to buy insurance and all that stuff. There are garages right next to me, so wouldn't be a problem having a building down there that I can see. I got enough land in the back of my lot. I'd like to keep it that size. But that's about it, I guess.
Okay. Anyone else to speak in favor of the appeal? Anyone here to speak against this appeal? Any questions from the board?
I just have a few questions.
Okay.
I noticed this lot is in the midst of a lot of commercial property around you.
Yes.
It's a very deep lot. Your hardship you're claiming this evening is because of theft, some theft,
Yeah.
in the expense of rental storage units, 2, and insurance,
Correct.
3.
And like you said, surrounding properties.
Surrounding properties, I've been out there, I've witnessed it, I've seen it. What's going to become of these cars in the future? You want to store these cars, obviously,
I've had them for years.
you've had them for years.
Yeah, Model T, I've got the oldest one, I had 66 years.
It's your investment, correct?
Yeah.
That's all I have.
Where do you keep them currently?
Well, I keep garages in the winter wherever I can find one in the street, because I can't get them all in my place. Because that little red building of mine is gonna go. I did squeeze one in there one time. Yeah.
So this is all for personal storage for yourself?
Yeah, there'll be other stuff in that building. You mean the one we're gonna put up?
Yes, sir.
Oh, yeah, there'll be other stuff in there. I got a lot of other things put in there. Mowers and utility trailers and stuff
You
like
don't
that.
plan to operate a business out of here or anything like that?
How's that?
No.
You don't plan to operate a business?
Oh, no.
You're going to clean up the property,
Yeah, that's what I'm gonna do.
and you're going to make it look a lot better than,
Get that big holiday out of that driveway, it's been there for years. Yeah.
And the location, I believe from the drawing I have seen, is to the very rear of the property, is that
Yes.
accurate?
Yes.
Any other questions from the board? Well, thank you, sir, you may sit down.
Okay.
Roll call vote, please. Or motion, I'm sorry.
I will make a motion, Mr. Chairman. Whereas applicant owner Emerson Falls 1005 Pittsburgh Road, Northwest Canton, Ohio 44720, applicant requested variance to place a 1,728 square foot accessory building located at 1005 Pittsburgh Road, Northwest Canton, Ohio 44720, parcel number 55-01403. To grant the following: a 1,228 square foot size variance required, 500 square feet permitted, 1,728 square foot requested, or modify the application.
Is there a second?
Second.
Okay, Mr. Pucilides. Any discussion? Not roll call vote, please.
Mr. Sutton,
Yes.
Mr. Pucilides,
Yes.
Mr. Reichel,
Due to the nature of the land and the way it's situated, I vote yes.
and Mr. Schultz.
Yes. Your appeal's been granted, sir. You can talk to Mr. Ferrara at some point in the future.
You got it.
Yeah, thank you.
You're welcome. Have a good evening. All right, our next appeal is appeal number 1272-18. Applicant Denise Armitage, 76 Manning Blackmail Circle Northwest, North Canton, Ohio 44720. That's parcel number 55-0250. Applicant requests an appeal in regard to the decision of the Plain Township Zoning Department relating to the application of Article 6, Section 602.1 of the Plain Township zoning resolution. Specifically relates to Section 602.1 fences, walls, and hedges. The property is zoned R1 Single Family Residential District and is located in the northwest quarter of Section 5. Is there someone here to present this appeal? Please come forward, sir.
My name is Steve Armitage.
Did you get sworn in, or are you counsel?
I'm actually technically counsel here this evening, but I don't mind being sworn in since some of the events did precede my individual capacity. So,
Could you raise your right hand?
Yes.
Do you swear or affirm the information you're about to present is true and accurate to the best of your knowledge and belief?
yes, I do.
All right, can you state your name and address and the basis for the appeal?
Yes, my name is Steve Armitage. I live at 7690 Bucknell Circle Northwest, North Canton, Ohio, 44720. I have lived there for close to 30 years. Also, having lived with me there full-time is Mrs. Denise Armitage, who is my mother, who's technically the complainant here this evening. I would have brought her along, except I would have needed to retain the services of both an audiologist and Greek translator. So I would figure at this point it would be easier just to have me here.
Okay. All right, Mr. Armitage, if you can please just state the basis for the appeal. I know everyone has been provided a copy of the documentation you've submitted, had an opportunity to review the same, but if you can please state the basis.
Yes, I'm happy to do that. I'll try to be as brief as I can, but since I am technically the appellant here, I need the record to reflect what I consider to be conflict of interest and abuse of discretion on the part of the Plain Township Board of Trustees and Zoning Department. Now, again, I think you have a pretty lengthy document in front of you. I've tried to give you a chronology of events that have taken place over the last 2 years. Actually encountered more, and I actually should have been here, in my opinion, 2 years ago. And I've actually encountered more roadblocks and detour signs than I did just trying to get here this evening. Normally it takes me about 5 minutes to get here, and I think it took me close to a half hour. But after 2 years, I'm very happy to be here. I would say in my 30 years of practice, I have seldom seen this much time, effort, and money. In this particular case, at least $12,000, probably more, spent on behalf of the township to retain counsel over an issue which I think is very simple and could have been easily resolved a couple of years ago. Specifically why I'm here, as Mr. Souls had referenced earlier, Plain Township has had a zoning ordinance on the books since at least 2006. Maybe earlier. I know there was a massive rewrite of the zoning regulations. And the zoning regulation we're talking about, 602.10, was in there as early as 2006. So it's been on the books for 12 years. Deals with a number of things, but it specifically says that residents of the township are permitted to elect fences, walls, and hedges as long as they're not over 8 feet high. Unfortunately, there was never any definition inserted for hedges until about a year ago, and as we will talk about later, I think that was invalidly adopted by the Plain Township Board of Trustees. But regardless, when there's no definition in a statute or a zoning regulation, you generally refer to the commonly understood dictionary definition of the term. That's not that isn't just my legal opinion, that's actually the opinion of the U.S. Supreme Court and the Ohio Supreme Court. When you have an undefined term, it's customary just to go to the dictionary definition and use it to define it. In this particular case, as as I said, there was no definition of the word hedges. And what I have never been able for 2 years to get across to Plain Township is that a hedge is not a type of plant. Let me repeat that. A hedge is not a specific type of plant. If you look at the word, look up the word hedge in any dictionary, any English-speaking dictionary in the modern world, you'll find that a hedge is a noun that describes a series of plants that are placed in such proximity that they form an artificial barrier. It can be any one of a number of plants. It can be trees, it can be bushes, it can be shrubs, it could be 20-foot tall watermelons, it could be bamboo shoots. It doesn't matter. A hedge means it's an artificial barrier. Now, I first approached the Plain Township zoning department and spoke with Mr. Ferrara. Am I pronouncing your name correctly? Is it Ferrara or Ferrara?
Ferrara.
Ferrara, okay, thank you. I've heard it both ways. Almost 2 years to the day, it was like September 8th of 2016. So that's when this entire saga started. And the reason I approached him, and I went personally to his office and met with him, was that behind my backyard, the neighbors have had for some period of time a row of what I would call evergreen trees or Christmas trees. There are about 21 of them over covering just 120 feet. There are a couple of oak trees in there too, and these were not naturally occurring. These were put in back when the residents bought the house in they built the home. They built it in the early 90s, I think. I bought my home in 1991. When I first bought it, you could just see right across the yard, and you could see both houses and the decks. And I can understand the need for some privacy. And when they were first put in, I think the trees were about, 4 or 5 feet tall. They were actually trimmed for a while by one of the previous owners. But over time, they grew to significant heights. They are now, I think the memo says 20 feet. They tower over the house, over the neighbor's home in the backyard. And that's a large, very large 2-story home. And the trees tower over the home, so I'm guessing they have to be over 20 feet, probably 25 feet by now. And I provided you some pictures. I have some others that I brought with me, but it is quite a barrier. It's a jungle out there, and I mean literally. And when I say a barrier, I mean you could not walk through it without getting scratched up. So my feeling was that these Christmas trees, because they were a hedge, should not be over 8 feet high, and that residents should be required to trim that back to at least 8 feet. I explained that to Mr. Ferrara, who looked at me sort of askance and said, well, I don't think that the word hedge is in the definition. I showed him a copy of it, and he went back to his desk and he leafed through some pages, and he came back and he says, I'm not going to do anything about this. And I said, well, may I ask why? He says, well, I don't think a tree's a hedge.
Mr. Chairman, I'm Jim Matthews on behalf of the zoning administrator tonight. I'm going to object to the history of matters that have already been concluded, in fact, processed and litigated in the courts and are not appropriate for this evening's hearing. This evening's hearing deals with an application complaining about a zoning violation submitted in May of 2018, duly considered and an opinion offered or decision rendered by the zoning administrator from which this appeal follows. So for the record, I'm objecting to the consideration of any of those historical matters.
May I ask who you're representing?
I'm James Matthews, and I'm representing the zoning administrator this evening.
You're representing him in his personal
I
capacity?
believe I've said that twice now, and I'll say it again.
You're not representing the board, you're representing him in his personal
I
capacity?
do not represent the board. The board is serving tonight in a quasi-judicial capacity.
Board of Trustees, not this board, the Board of
The Board of
Trustees.
Trustees is not a party before this proceeding. I'm representing the zoning administrator.
In his personal capacity?
I don't know what you mean by his personal capacity.
You represented him in his personal capacity in a lawsuit that I filed against him and Mr. Hawes. Is that the reason you're here this evening?
I did, and I also represented him in his capacity as zoning administrator.
Correct.
I believe it's his decision being appealed.
Stop.
Yeah.
Stop. He's indicated he's representing him in his capacity as the zoning administrator.
Correct. Thank you.
As far as your objection is duly noted, I'm going to let you provide a little more history and background. Okay. We have quite a bit of it in the record before us.
I understand.
Now we have quite a bit of it right
But
here.
I'm going to give you a little latitude to provide a little bit more background. You can just kind of get to the ultimate appeal, which is the May 2018 appeal. But I do understand what you're.
Mr. Stoll, I'm happy to do that. Mr. Reichel, I can see you're upset. I will tell you, sir.
I'm not upset
No, no,
at
I can
all.
see it. But I can tell you, sir, that my burden here as the applicant is to prove an abuse of discretion, and I have to get that on the record,
Absolutely.
whether you like it or
understood.
not. And I need to have you given some leeway to do
Absolutely.
that.
I think Mr. Souls has given you that lately.
Well, I would hope that we could understand really what's at stake here. All right, so we then I then asked Mr. Ferrara whether there's a way to appeal his decision. He says, no, this is not a permit or a variance issue. You can't go to the Board of Zoning Appeals on this. And take the matter to Mr. Hawes. I actually called Mr. Hawes. He came out to the property. I wasn't there at the time, but he was very nice. Went out to the property, left me a very nice voicemail, which I put in the record. He also indicated that you don't have a right to appeal. Those trees have a right to be there. Our zoning inspector is correct. Therefore, there's nothing more we can do for you. All right, fine. I file a writ of mandamus. I don't know if all of you have law degrees or not, but a writ of mandamus is technically a lawsuit, but it's not asking for damages. All you're doing is going to the court and saying, I believe a specific law or statute is not being enforced properly. I would like the court to order the public authority to enforce the law. You're not asking for money. I've never asked for money or damages. All right, I want to make that clear. The court, Mr. Matthews comes into court and says, well, actually, he did have a right to appeal. We were wrong, we told him he didn't, but he actually did, and therefore he didn't exhaust his administrative remedies, and therefore he should be dismissed from the case. The writ of mandamus was filed directly with the 5th District. You're allowed to do that. You can file it either with the Common Pleas Court, the District Court, or the Ohio Supreme Court. The District Court ultimately agreed, and they said even though you've acknowledged that he got erroneous information, he didn't exhaust his administrative remedies, he's dismissed. I think actually that was the correct ruling. I accepted it. What angered me, and I don't mind telling you I was angry, was that at some point, the board and Mr. Ferrara must have known they gave me wrong information, because that's what their counsel argued. He argued that, yes, we did give him wrong information, but it doesn't matter. My feeling as a constituent dealing with public servants is, if you make a mistake, you own up to it. I made plenty of mistakes in my life. I try to own up to them. I try to correct them. And I think if the public servant says to you, this, you can't appeal this, and then he finds out, and he must have found out, and I have evidence later that we'll talk about, that they must have known at some point that they didn't give me wrong information, why not pick up the phone and tell me, we're sorry, we made a mistake. Go to the Board of Zoning Appeals. State your case. They never did that. So then I filed the second lawsuit, and I wanted to get to the bottom of this, because one or two things had happened. Either they intentionally lied to me the first time, which I don't believe is the case. I actually think they made an honest mistake. I think they made an honest mistake. But they had a chance to correct it, and they never did. And that upset me. And I think anyone here would be upset, and I can give you a good analogy. If you're, let's say that Plain Township supplies your water, and normally your bill is like $50 a month, and then one month you get a bill for $500, and you complain about it. And the person comes out and says, your meter's fine, our software's fine, you must have a problem, you must have a leak. Maybe your kids turn on the water when you were on vacation. We're not at fault. And then 2 days later, their software developer comes in to do an upgrade, and he finds out there's been a glitch in the system. And every one of 10,000 people gets an extra zero added to their bill. Shouldn't they call the resident? These people, they should. You'd be angry if somebody discovered it. Hey, we actually billed you 10 times more than we thought, but then we decided to keep our mouth shut because our lawyer told us to. And our lawyer told us, we're not legally obligated to tell you the truth. We can keep our mouths shut.
I'm going to object to the inference that the lawyer may have conveyed to these two clients to tell people something that was untrue. I will adamantly say that's an absolute falsehood right there, and I object to it being made as a reference in this public meeting.
Could you tell us when you told Mr. Ferrara?
I'm not
I
going
have
to
no
disclose
questions,
my attorney-client communication with my clients,
All right.
but I am going to tell you, I've never told a
Objection
client
noted.
to lie.
Okay, I respect what you said.
Okay, he's allowed to testify? I don't think he's even sworn in. Did you swear him in?
I'm not testifying.
He
this
just
evening.
testified he never told Mr. Ferrara to lie about anything.
I'm responding to your gross exaggerated remarks.
No, you said you never told him to lie to anybody. Why don't you say that under oath?
All right, I'm gonna interject here. There'll be no questions back and forth between the two lawyers.
Am I being permitted to speak here,
He's
Your Honor?
going to make an objection. You can make your objection.
I have, that's all.
Make your note, then you can continue to speak.
I will also note that this is a quasi-judicial proceeding, and the emphasis on quasi. I'm not sure that, I don't know if I've been on the board, I don't know how long, have we ever entertained an objection? I think you'll have an opportunity to speak. You can write down all the notes you want, and you can talk about what Mr. Armitage said was incorrect. I'm not sure objections are necessary, and I think I fully expect Mr. Armitage to be able to say whatever he has to say today. I don't want him to say on appeal that he didn't have a chance to say everything he wanted to say today. So
That's fair.
I'm here, it's 6:25. I'm not going to leave until we're done. I don't have anywhere to go. I'm here for everybody, so please.
Thank you. And again, I would say they tried to keep me from speaking for 2 years, at least give me that opportunity this evening, and then they can talk for as long as they like. I'm here until then.
I'm giving you that latitude, but I'm also giving Mr. Matthews the latitude. If he wants to note an objection, he can note an objection.
Even though this is a quasi-judicial
Note
proceeding?
an objection.
All right, fair enough. We were at the point where we were in the second lawsuit. And simply again, there was a damages clause in that lawsuit, but I never asked for money, nor did I ever approach Mr. Matthews and tell him I would settle the case if he gave me X amount of dollars. This was never, ever about money. I was not interested in any money from Plain Township. I just wanted them to enforce their laws. And I was quite perturbed, again, that they knew at some point. They made a number of mistakes here. The first mistake is that they told me I didn't have a right to appeal to the court. The second mistake they made is that they never looked up the word hedge in the dictionary to find out they actually didn't move trees until later when they found out. And the third issue that I said really hurt me was they never just called me and said, we made a mistake. Give your appeal and we'll see what happens. So, and in fairness, Mr. Matthews was able to convince both the Court of Common Pleas, Judge Heath was presiding, and the 5th District Court to dismiss the case based on the holding that public officials are allowed to maliciously, and the holding's on page 10 of your opinion. You don't have to take my word for it, you have the site if you want to look it up. The public officials are allowed to maliciously misrepresent their interpretations of laws. Maliciously misrepresent. And the whole thing is, even if they maliciously misrepresent it to you, that you could not have an appeal, it doesn't matter. They still have immunity. Striking new law, in my opinion. And, I congratulate Mr. Matthews. I never thought that the court would go in that direction. I never thought the Court of Appeals would uphold that ruling, but they did, and I congratulate them. I mean, that's quite a coup. I'm not sure, if I'm running for re-election as a member of the Board of Trustees, I want that as my standard, saying I spent $20,000 of taxpayers' money to basically establish the precedent that I'm allowed to lie to you. But regardless, that's the law they want. That's fine. The other thing that's happening during this entire process is all of a sudden, they start to change the statute. Starting in September of 2017, running through October of 2017, and finally November of 2017, they attempt to adopt, and I don't think they were successful in doing so, but they attempt to adopt a change to the hedge ordinance. And basically what they do is they, for the first time, define the word hedge as just to be a shrub. Just a shrub. Not a tree, can't be a watermelon, can't be a bush. It's just a shrub. That's what we call in the law a subsequent remedial measure. And I think it is proof positive that they knew that they were wrong the first time. Because why would you change the statute if everybody understood the word hedge to be just a shrub? You wouldn't. There would be no reason to do that. And they did it for one reason, and one reason alone, was to stop me from coming back. And we have evidence that I'll talk about in a few minutes that verifies that. Because there was nobody else complaining about this. There wasn't a swarm of people coming to the zoning office and saying, well, these are trees, these are shrubs. Mr. Farrar wasn't going out every day and having to make these kinds of determinations. He would actually say at the zoning commission hearing, which we're going to talk about in a few minutes, that this is the only incident he knows of. And he would also state during that proceeding that the reason they were making the change is because their lawyers thought, their lawyers recommended it, their lawyers drafted the language, and the lawyers thought it would stop the lawsuit. And those comments are on videotape. They are part of the zoning commission hearing on this very issue. Because what happened was in September of 2017, they tried to pass an amendment. They did pass it unanimously. That amendment had to go to the zoning commission for their recommendation. The zoning commission voted it down 4-1. They proposed an amendment defining shrub and defining tree. The zoning commission voted it down. I urge you, in fact, I implore you, before you make any decision on this matter, is to view that zoning commission hearing. It's on your own website. You click on it. It's about 40 minutes long. It is incredibly educational. It is incredibly damning. Because what comes out is basically, after some confusion at the beginning, the commission asked, why is this being presented to us? And basically they did two, as being presented to them, to stop one person from coming before and challenging that. And that person was me. And basically the zoning commission decides, we don't want any part of this. We're voting it down. They also considered that evening an amendment to just define the word hedge as a shrub, to leave out the definition of the word tree. Again, they voted it down 4-1. As one board member said, and he's on tape, this is like taking a baseball bat to a mosquito. And guess who the mosquito was in this particular case? Let me give you a couple other references. And again, I strongly urge you to watch this videotape because they're considering the exact same issues that you're considering tonight. And I think it would be educational for you to look at how they handled them, how they were discussed, and why they arrived at their decision. At 4:05 of the videotape, Mr. Farrar was heard saying, the attorneys think that we should have definite definitions in the hopes this might stop the lawsuit. At 5:51 of the tape, he says, we want to be as specific as possible on the definition of trees so we can deal with what's going on. At 10:30 of the video, he says, I've looked all through the internet and a hedge can be a row of trees. Let me repeat that. He says, I've looked all through the internet and a hedge can be a row of trees. He obviously knew at that point, he must have known before, but he obviously knows at that point that I was right, that a hedge could be a row of trees. And yet they move on. They never contact me. They never correct their mistake. They simply go on to try to amend the statute. At 17:50 of the meetings, Mr. Seberg says, why did this case go from the zoning director directly to the court? Why were the administrative remedies not exhausted? Mr. Ferrera says, I think that was one of the arguments. In 1920 of the tape, he admits that the entire redraft, the entire amendment was prepared by the attorneys. He's asked who the attorneys were. He identifies them as Mr. Matthews and his law firm. At 2150, Mr. Crawford asks, is there a history of cases dealing with hedges and trees? Mr. Farrar replies, this is the first one I know of. At 23 minutes, Mr. Harris says, isn't the plaintiff arguing that a line of trees makes it a hedge? Mr. Farrar answers, that's my understanding. At 26:15, Mr. Crawford asks, could this be an overreaction by the board to one single thing? To which Chairman Harris responds, maybe. A few minutes later, at 27:50, Mr. Rambacher says, it sounds like we're taking a baseball bat to a mosquito. At 34:10, Mr. Rambacher says, I struggle with how the board can say words are clearly understood, but then say we would like assistance to nonetheless add definitions. Mr. Crawford responds, it's probably suggested by their counsel so as not to be inconsistent at trial. Who knows why they put that in there, Mr. Crawford continues. They may have their own motives that we are not privy to. All a matter of public record, to which Mr. Rambacher says, bad facts make bad law. At 42:36, Mr. Crawford says, a hedge could be a row of trees. At 43:35, Mr. Farrar says, I just looked up the word shrubs on the internet, and I came up with a definition of hedge, and it says it's a wall composed of plants. A wall composed of plants. Not just shrubs, but everything. Obviously, pretty conclusive evidence they knew they had made a mistake, and they were desperately trying to correct that mistake. Which takes us to the amendment. And what they do is they first pass an amendment that defines hedge and tree and wall. Goes to the zoning commission. Zoning commission says, we don't want any part of this. We reject the recommendation completely. No modification. That goes back to the board. In November of 2017, the board has three options under Ohio law. They can accept the recommendation, which in this case would mean we accept the decline. We're not going any further. Amendment dies. Option number two is they can decline the recommendation and say, we're not listening to you. We're going to pass the amendment as we presented it. They don't choose that. Even though they do sort of dismiss the recommendation, what they do is say, we're going to modify this recommendation, and we're going to take out the word tree, and we're just going to take the word hedge, and we're going to define it just as a shrub. I don't think they're allowed to do that, because at that point, that's a brand new resolution, and that has to go back to the zoning commission. Their argument is, well, we're modifying what the zoning commission wanted us to do. Well, there is no recommendation. There was nothing to modify. You modify something in writing. You modify a draft of something. When they come back to you and say, 0, we don't want you to do this, there's nothing to modify. You have the option of saying, we're going to reject your suggestion, we're going to adopt it as is. But that's not what they did. They really came up with a new amendment. So the amendment number 57117, whatever it was different on November of 2017 than it was in September. I don't think it was validly authorized. And I'll finish with this. And, you know, they always said in law school, you try to leave your best argument at the beginning or at the end. And what I would point out to you is that even Yeah. I would point out to you that even after all this, if you decide, well, you know, Steve, maybe they didn't cross all the T's and dot all the I's, but it's not an abuse of discretion. They maybe should have called you, but it's not. They were within their legal rights. We don't care. They adopted a change. Maybe it was a conflict of interest. They never disclosed, by the way, during this whole process that litigation was going on. Mr. Matthews testified at the November 17th hearing that the reason for the amendment was because a lawsuit and an appeal had been denied. Well, that's misleading. That's inaccurate because no court, and I want to make this clear, the Common Pleas Court, the 5th District, the Ohio Supreme Court never reached the issue of whether a tree is a hedge, is a shrub. There is no court determination of that issue. So to leave people with the impression that I filed a lawsuit and it was denied, and the appeal was denied, is simply not true. My writ of mandamus was denied for lack of jurisdiction because I didn't exhaust my remedies. It had nothing to do with the determination of whether a tree is a shrub. But they clearly are leaving people with that impression. But I wanted to finish up by saying, you know, even if you want to dismiss all that and say, well, okay, it doesn't really matter, they passed an amendment, and now the only place in the English world, the English-speaking world, where a hedge is defined as a shrub is Plain Township, Ohio. That's the truth. You won't find it anywhere else. They defined a shrub as a bushy, woody plant, generally with several permanent stems instead of a single trunk. That's their new definition. So they're basically saying a hedge can only be a shrub, and a shrub is a bushy, woody plant, generally with several permanent stems instead of a single trunk. Well, guess what? They just defined the Christmas trees in my backyard. Because they're bushy, woody plants, and many of them, of the 21, half of them, have more than one trunk. There are some there that have a single trunk. They're there with multiple trunks. So guess what? Even if you want to allow this amendment, the neighbors are still in violation of even the new Plain Township definition. So I leave you with this. I do want to, and I want to make one other quick point. This is the letter this is the determination letter I got from Mr. Ferrara that denied our claim. Mr. Ferrara, you signed this, right?
You know, there's no questions. You can present.
All right, that's fine. It's in your material. Let me just reference what concerns me. It says on the last page at the top, first paragraph, Section 602.10 of the Plain Township zoning regulation was never intended to include or address fully grown, mature evergreen trees, such as the one your client's neighbor planted decades ago. You were informed of this point last year, and the amendments to the resolution have ratified and reinforced this position. Well, number one, I was never informed of that. Number two is I actually don't believe Mr. Ferrara wrote this letter. I think Mr. Matthews wrote this letter. I can sort of tell from the tone. And this statement is false. Because to say that the Section 10 was never intended to include trees, there's no legislative history that says that. There are no notes that say that. There are no minutes from the framer. They say that. There are no notes or minutes from other meetings that say a hedge was only permitted to be a shrub. There's no evidence of that. You know why? Because they made it up. This has been on the statute since 2006. And their argument is, it's always meant shrub. Where's the evidence of that? Zero. You know what the evidence of that is? They amended it. They amended it in 2017 after 2 lawsuits to make it look like it was always meant to be a shrub. That's an abuse of discretion. And I would hope, I'm happy to answer any questions, but I would simply ask that Plain Township enforce its laws. That's all I've ever been seeking here. That's all I have.
Okay. Thank you, Mr. Armitage.
Thank you.
It's Armitage.
Armitage. Is anyone else here to speak in favor? Mr. Armitage's appeal. Is anyone here to speak in opposition?
Just me, if I may. Again, Mr. Chairman, members of the board, Jim Matthews.
Name and address.
Yeah, sure. It's James Matthews, 400 South Main Street, North Canton, Ohio, 44702.
Raise your right hand. Should you swear or affirm the information you're about to present is true and accurate to the best of your knowledge and belief?
I do. Out of respect for Mr. Pusali's comments about objections, I did not rise and object to the commentary by the appellant's counsel relating to the enactment process of the additional definitions in the zoning resolution. But just for our record, I object to that matter being considered by the board because the board does not have jurisdiction under 519.14 to review the procedures of a legislative enactment of any amendment to a zoning resolution. With that, then I'll move on to what is actually before you this evening. On May 29th, 2018, a letter was submitted by the appellant's counsel on behalf of the appellant, Denise Armadas, for the purpose of alleging a violation on a neighboring property. The letter is very clear, the letter is in the record, and it alleges that the violation is the result of 20 densely packed evergreen trees that are located on the neighbor's backyard property. That's the sole factual issue that we need to deal with. There are evidently 20 densely packed evergreen trees on the neighbor's property. The question then becomes, when a notice like that is received, it's properly presented to and processed by your zoning administrator, who both by the revised code as well as your zoning resolution has the principal authority on dealing with enforcement issues. My position is that your zoning administrator has looked at the zoning code applicable to this May 29, 2018 complaint and very fairly and very reasonably applied not only the section that's at issue, 602.10, but also the definitions that have been enacted to aid in the application of 602.10. His letter, the zoning administrator's letter, denying that there was any violation on the neighbor's property, principally references the two definitions that are applicable for this evening's proceeding. The one being a hedge and the other being a shrub. These are two sentences. We're dealing with two sentences. The appeal tonight involves not the interpretation or construction of two sentences, but simply the application of two sentences. And I believe your zoning administrator has correctly applied these two sentences. A hedge is a row or line of closely spaced shrubs, the key point of that definition, planted and trained in such a way as to form a barrier, screen, or fence, or to mark the boundary of an area. What the Board of Trustees did in passing these additional definitions was add clarity, add instruction on the application of 602.10 by then defining a shrub. And interestingly enough, the appellant's counsel gave you part of the definition of shrub that was passed by the Board of Trustees. The full definition states a bushy, woody plant generally with several permanent stems instead of a single trunk, thereby distinguishing it from a tree, planted and trained to serve as a landscape feature. It is clear that in the application of this word, this defined word shrub, a shrub is distinct from a tree. 20 closely, densely packed evergreen trees on a neighboring property do not fit the definition of a shrub. If they don't fit the definition of a shrub, they then don't fit the definition of hedge, and there is no violation to be considered under 602.10. That is what is articulated in your zoning administrator's letter that's subject to this appeal, I believe the standard is not abuse of discretion. The standard is whether or not the zoning administrator's decision is correct. It's whether or not there is correctness in his decision. His decision is correct, and as a result, I would request that you deny this appeal, thereby affirming the zoning administrator's determination or order that's under appeal. I'm here if you have any questions. I'll certainly entertain those. Otherwise, I always hate to argue cases and say this is pretty straightforward and pretty simple. My position is this is pretty straightforward and pretty simple. These are evergreen trees that have grown to the height of 30-some feet, or 20-some feet, or 30-some feet over decades. These do not qualify as a shrub hedge under the current and active zoning resolution.
Thank you.
Thank you.
Anyone else here to speak?
Have a few minutes on the ball.
Anyone else here to speak against this appeal?
I guess I will.
Yes, sir. If you could please come forward. Please raise your right hand. I don't believe you responded earlier.
No,
You swear or affirm the information you're about to present is true and accurate to the best of your knowledge and belief?
I do.
Please state your name and address, sir.
Jeff Mazer, 2630 Sheffield Street Northwest, North Canton, Ohio, 44720. I'm late to the game, just bought the house, did not know about the prior history up until, the days before closing.
Which house are you referring to?
The house that is in question about the
So you bought the
trees that are
Cobra
considered,
house?
yes, that's correct,
Oh.
about it from Cindy Copeland, correct. To any stretch of my imagination, I couldn't imagine these trees, as we've discussed, could be considered a hedge. I would think if we interviewed 40 landscapers off the street, just found the yard and said, what would you call this? I think most of them would call it a tree. I understand council's argument, it's eloquent, but again, I'm new to this, but I bought the house because of the beautiful tree-lined backyard. It was something, I enjoy privacy. With these trees being removed, certainly privacy would no longer be available. And it's one of the main motivators why I bought the property. It's beautiful. And, if you go around all of the Bobolink community, I guess there's a bunch of hedges that could be applied to the same theory. But there's certainly, that's what, I'm assuming that's what Bobolink, that area is known for, is they're beautiful, mature trees. And if those are in question, I'm in question that I bought the property because it's something that enticed me. So, as far as the attorneys go back and forth, that's fine. But for my own personal preference, I don't want my privacy removed. That's why I purchased this property. Those trees are on my property, and I'm certainly would be a good neighbor, and I'm all about keeping trees trimmed and et cetera, et cetera. But if you're talking about reducing a 25-foot evergreen tree to 8 feet, it's not something that sounds feasible to me. So, appreciate your time.
Thank you, sir.
And I'm not trying to make light of the situation by any means. I understand his needs. Thank you.
Anyone else here to speak against the appeal? Mr. Armitage, we will let you present your rebuttal here.
Yes, just 3 minor points, and I just want to address specifically what Mr. Matthews said. He indicated at first that you don't have the authority to look at what the zoning commission did. Actually, that's not true. Under state law, boards of zoning appeal, such as yourselves, actually have a lot of leeway, and I'm just trying to find an actual so it's in the conclusion section, so I can find it. RC 519-14B gives every board of zoning appeals in Ohio, every board of zoning appeals the authority to authorize in specific cases such variance from the terms of the zoning regulation as will not be contrary to the public interest, where owing to special conditions, the literal enforcement of the resolution will result in unnecessary hardship, and so that the spirit of the resolution shall be observed and substantial justice done. you have very wide authority to do substantial justice here. You are not simply restricted to the issue of whether a shrub is now a tree or not, and you certainly are able to look at how this whole process worked and how there was a series of material misstatements and omissions. I would also say, in terms of Mr. Matthews' argument, that Mr. Ferrara correctly decided the issue. I would quarrel with that, because as I pointed out in my brief, Mr. Ferrara had a conflict of interest this second time around, because at the time he's making this decision, he's still technically a defendant personally in a lawsuit, which Plain Township, by the way, was not a party to. The only defendants are Mr. Ferrara and Mr. Hawes. Mr. Matthews was defending them personally, although Plain Township was not involved. I believe Plain Township was paying his $20,000 fee, but they were not, Plain Township was not a party. The point being, though, Mr. Ferrara was at the time a defendant in a lawsuit that I had filed against him. At that point, he should have recused himself. If I had a lawsuit pending against any one of you tonight for even hitting me with your car, it would be appropriate for you to recuse yourselves and not be here. If I were in front of a judge who had rear-ended me in Belden Village arguing, some huge class action, it doesn't matter. He should recuse himself. And he must recuse himself. And I would suggest to you that this was not fairly determined by Mr. Ferrara, because he should have recused himself. Because technically at that time, the decision was on appeal to the Ohio Supreme Court. We had not had a final resolution of the issue. And he should have deferred it. I believe, has an assistant zoning inspector he could have deferred it to. I believe he could have given the issue to the board, to the Zoning Appeals Board, the commission. Maybe he could have gotten a zoning inspector from another jurisdiction. But in no way, shape, or form should he have been the one at that time. That's not an attack on his character, by the way. I think he's a good person. I think he's an honest man. But obviously, if somebody's suing you and you have to make a decision regarding their property, it's a conflict of interest. And you need to remove yourself from that situation. And they didn't in this particular case. Lastly, in terms of the argument that the trees in my backyard don't fall under the new definition, I wonder how Mr. Matthews would know that. He's never been there. I wonder how Mr. Ferrara would know that. He's never been to the property. To my knowledge, only Mr. Hawes has ever been to the property, and he has no decision-making authority here. I can assure you that the trees, or whatever you want to call them, are bushy woody plants. They are multi-stemmed, and they fall within the definition, the old definition and the new definition of a hedge. And if Mr. Ferrara had wanted to do his job, you'd think he would at least come out there and looked at them and taken pictures, but he never did. Thank you.
All right, questions from the board?
I have questions. I have several questions. Mr. Armitage.
Armitage.
Can you please come forward again?
Yeah.
sir?
Mr. Armitage, if I understand what you're asking us, we're here today because you want us, the Board of Zoning Appeals, to rule that the zoning director should enforce the zoning code.
I'm here asking you today to, yes, enforce the zoning code.
Because you feel that he has failed to enforce the zoning.
I feel, sir, that the hedge has always included trees, that even under the new definition that they tried to put up was a subsequent remedial measure, which was improper, because they're in the middle of a lawsuit and they're changing the rules in the middle of the game, basically.
Look, I get all the background.
But also,
but at the bottom, what you're asking for us,
Yeah.
you're not here to ask for a conditional use permit
No.
or a variance from certain
No.
feet requirements. What you're asking for, if I understand.
I'm asking for
correctly-
6010 to be enforced.
Yes, you're saying that the zoning director should enforce.
60210.
60210.
Yes.
Okay.
Not seeking anything else other than the enforcement of that section.
No.
here's my concern, and I don't want my comments to be construed in any way, whether I agree or disagree with everything that you've given us and said, okay? My concern is with the Board of Zoning Appeals, whether this is something that we have jurisdiction to rule on. The 519.14A states, gives us what powers we have, and it says the Township Board of Zoning Appeals may hear and decide appeals where it is alleged there is error in any order, requirement, decision, or determination made by an administrative official in the enforcement of sections 519.02 to 519.25 of the revised code, or any resolution adopted pursuant thereto. There isn't a claim of enforcement. There is a claim of a failure to enforce. My reading of the code is that specifically we can only deal with, for example, if there's an enforcement by the zoning director, and if he would enforce this code section against the Mazers, and then they would bring an appeal to us. That would be an enforcement of the code. Here, it's a failure to enforce, and the code section doesn't talk about us dealing with failures to enforce.
Actually, the code does specifically say the Board of Zoning Appeals has a right to review any determination by the zoning inspector. And by the way, this issue has already been decided by the 5th District.
Well, I'm glad you mentioned the 5th District, because I looked at that one-page opinion, and I have it here somewhere. And, oh, it's right here.
Right on top.
Right on top. And the judge said, the court said, the zoning director made a decision or determination by stating he was not going to do anything about relator's complaint. Relator has or had an adequate remedy at law by way of utilizing the township's appellate process. Relator is in possession of the appeals form, as is evidenced by the fact that he attached it to his complaint. Well, I don't know what the appeals form says. That's from our zoning. And quite frankly, what I'm concerned about is what the Ohio Revised Code says.
My revised code is clear that any determination of the zoning inspector.
Now, it says in the enforcement of sections.
I don't know which section you're looking at, but I know the section that Mr. Matthews cited is very clear.
Well,
And I would say at this point you're overturning the 5th District. I mean, I was bounced because his determination was reviewable.
Wouldn't be the first time the 5th District got something wrong.
Oh, I agree.
About one of our cases.
Oh, I agree. I specifically think this whole malicious misrepresentation thing is a travesty, but that's it. I mean, that's like double jeopardy. I'm being told you have to take this to the appeal, and now I'm being told, well, this isn't appealable.
Well, the 5th District doesn't specifically discuss the powers of the Board of Zoning Appeals, and it doesn't really tell us, what power we have. It doesn't speak specifically about dealing with a zoning director who refuses to enforce a zoning code. And I do have a case that's out of the 7th District, Mahoney County, that says exactly what I'm saying. Caroce versus Borden Township Board of Zoning Appeals, that's CARROCCE. 1993 case that specifically says, quote, a claim of failure to enforce is not a type of appeal a Township Board of Zoning Appeals may hear. The Zoning Board of Appeals therefore lack jurisdiction over Johnson's claims of the zoning inspector's failure to enforce. We find the board does not have authority to hear claims of failure to enforce as Johnson would contend, end quote.
Well, it's not a 5th District case.
It's not, but the judge in the 5th District case doesn't go into detail, and it doesn't specifically
Yeah,
say.
if we look at the plain township form, it does say determination. It copies the statute. It says any determination.
Determination of of the enforcement of
It
section.
doesn't say that, the form says any determination. In fact, I provided them the form. Because I actually agreed with you at the beginning, the Plain Township zoning regulations are pretty poorly drafted. You actually could make an argument that it wasn't appealable. But I do agree with Mr. Matthews, who pointed out there's a state statute that's very clear on it. And the state statute talks a little about determination. I mean, that, he refused to enforce the law, that's why I filed a written mandamus
Yeah, see,
before him.
I don't, is there any case law that says that our job as a Board of Zoning Appeals is to make sure that the zoning director enforces the zoning codes? Because that's not what Judge Delaney said. She did not say that we have the authority to tell the zoning director how to, that he has to go out and enforce the zoning codes.
You have a duty to review any determination that he makes, which I brought to you. He's made a determination which I believe is wrong, you have a duty to review that and make it right.
And that's your argument, that he made a determination, he's incorrect, consequently you appealed that determination, we have the obligation to review that.
Yes.
Is that correct?
Yes.
Couple questions I have. First, the amendment that you spoke of, that was adopted.
Yes.
Did you ever appeal that? See?
No, I wasn't a party to anything, I was never even given notice that that was being considered.
So the resolution, as it reads relative to the definition of a hedge, shrub, tree, essentially reads as it is and how it was adopted by Plain Township Board of Trustees.
You're talking about the amendment?
Yes.
It reads as it is, I think it's invalid.
That's never been, my understanding, that's not been appealed, that's in effect currently.
Again, have I taken that argument to a court? No, is what you're asking.
Yeah, that's what I was asking. I didn't.
No, I have 2 years to do that.
I'm not aware that that.
I have a 2-year statute on that, so we're well within that if it comes to that.
This, you never raised this issue back 10 years ago.
Yes, I repeatedly raised it with Mrs. Coberline.
I met with the Plain Township Board of Zoning.
With the zoning appeals board?
Correct.
No, I didn't, the last thing I wanted to do was actually go to court with my neighbors, to be honest with you. And it just became an intolerable situation. The other thing that was never mentioned was during the time that the Coberlines lived there, Mr. Coberline, who subsequently got a divorce from Mrs. Coberline and left the premises, actually did a good job of trimming those trees. For a certain period of time, they were actually kept at about, I don't know, whether they were kept at 8 feet or 9 feet, they were kept at a reasonably level. He would actually have his lawn service come over and trim the trees, or trim the branches that were reaching over into my yard, although he's not legally obligated to do that. And unfortunately, after he sort of left the premises, things, the trees became more unkempt. So I did address it with the neighbor numerous times, and was never able to get any satisfaction. In fact, one of the arguments that Mr. Matthews raised was that I should have sued the neighbor first. He claimed actually that that was because under state law, I have a private right of action to enforce a zoning violation. And Mr. Matthews actually argued that I hadn't exhausted my remedies because I didn't sue my neighbor and I should have sued my neighbor first. I don't think that's right. The court never ruled on that. But that's something that the township recommended. If you listen to the voicemail from Mr. Hawes, he strongly recommended that I sue my neighbor. I didn't want to do that. I felt that this could easily be resolved by just enforcing it.
So at least from what, 2006 to 2016, you didn't raise any issue with the Plain Township Board of Zoning?
No, there's no statute of limitations on zoning regulation.
I just was
All right,
asking
no,
whether
the
or not
answer-
you raised any issues.
No, I never came to, no, it wasn't until September.
Please, one person, your lawyers, you know that, one person.
No, it wasn't until September of 2016 that I first raised the issue.
Do we have a copy of the appeals form?
It's got to be in the record somewhere.
Did you?
It's on the internet site, it's on the Plain Township.
appeal form, though, is for this case, and not for the last one. But it says this appeal must be filed within 20 days of the date of the order requirement decision or determination of the zoning director. And that's been the same over the years?
Yes.
Yes.
And are we referring to, what, about 12 different evergreen trees?
21 trees on
Well,
124.
are the 21 trees, are some of those oak trees?
I think maybe one or two.
One or two.
And none of them are naturally occurring, by the way. They were not there when the property was purchased by the Covalines. They were all put there on the planted and cultivated on the corner. This is not a natural occurring situation.
Do you have any photographs of the trees that you're referring to that basically have multiple trunks? I saw something you attached to your brief that wasn't for this property, I believe.
May I approach?
Yes.
You keep all of these. I don't know if these are the trees, and Mrs. Coverline is now Mr. Mazur's on the roadway. This picture was taken to indicate that that's a barrier. Whether you can tell that some of them are multi-stem or not, I don't know. They clearly are. Unfortunately, Mr. Murray can't testify that he's never been to the property. I would also like to submit these, by the way. These, by the way, are shrubs. And I know they're shrubs because after a couple of years, I've sort of become an expert on this. They're shrubs because you can tell that they actually point upward, they're lighter green in color, and they do have multiple trunks. That's also, one of my neighbors has those. These aren't
the trees you're referring to, though.
no, that's from another neighbor. So my point is, this is a series of shrubs within Plain Township.
These are unmarked court.
My point,
Looking more specifically at your property.
the only picture of that would be this.
This
And
one?
there's one attached on the trees.
Yes, I've seen those attached.
Yes.
My point is, I don't see an aesthetic difference between the shrubs and the trees. Keep all of those.
Thank you. Thank you.
Any further questions from the board?
I think you've answered my questions, your two questions. No, not for me.
Well, I'd like to ask Mr. Matthews a question.
Certainly, Mr. Pusalides, what can I do for you?
Do we have jurisdictions?
Well,
Based on, you heard my argument, do we have jurisdiction?
I would answer it as yes. The reason being that I would recast the question before you. And I appreciate the way you cast it as more of an enforcement versus non-enforcement issue. Are you specific, is he the applicant? And it's not really he, it's the appellant that he's representing. Is the appellant actually seeking an order that would direct the zoning inspector to enforce? I don't believe that's the scope of your jurisdiction. I think your scope of jurisdiction is to rule on whether or not his determination that there is no violation is accurate. He rendered a determination, issued an order, whatever you want to call it, under those multiple words used in 519.14a, that you should be able to review the correctness of his determination. And I think that's the scope of your jurisdiction.
Well,
I agree with that.
So then, we could have people calling up, asking the zoning director to interpret multiple potential zoning violations, and if he refuses to, it says enforce it, we can have multiple appeals to the BZA.
You could.
Do we have any case law that supports that, I came up with this one, I'm gonna tell you, I did research on this, let me know
Sure.
who I can send my bill to. It's supposed to be funny.
I got it. Denise.
So I only found one case, and I don't consider the opinion of the 5th District, you know, it doesn't tell us, to me, it does not tell us that we have jurisdiction. It just talks about this township form, and the township form is not the law of this state. The
Yeah, we
law
all
of this
know it's
state-
delegated, it comes from the revised code, your resolution could not grant greater jurisdiction than the code does. I accept all of that.
Okay, so I looked, I couldn't find any case where a zoning director failed to enforce, and the Board of Zoning Appeals said to the zoning director, enforce this law. The only case I found was this case out of Mahoney County where the court, and my instinct was, do we really have jurisdiction here? Do we really, is this what we're supposed to be doing? And admittedly, it is Mahoney County, it's the 7th District, and it's a 1993 case. But I think it correctly says that the failure to enforce is not the type, that's not what we're here to do, is to tell this guy what to do. I think that's more of a political issue, maybe with the Board of Trustees. And that's what I'm struggling with. So I don't have any case, I don't know of any case law where a court said the Board of Zoning Appeals has the power to tell the zoning director to enforce the zoning code.
Yeah. And again, cast that way, I don't know that there's any case law that says you have the authority to enforce or to force him to do something. As I argued before the courts below in the other cases, which by the way have nothing to do with tonight, but I've made that point. In those other cases, the statute on enforcement itself, which is 51924, has a very important word in it too. It says that the Board of Township Trustees or the zoning inspector, zoning administrator, may enforce violations of the code. So it's always been my position, it's.
Okay, I'm going to object to that, because he earlier said that we shouldn't be considering cases from before, and now he's coming up with a totally new argument that has nothing to do with tonight's hearing.
But it reinforces that it's, what you're saying, it's his discretion.
He has discretion in the enforcement, absolutely.
Right, so since he has the
That's
discretion.
not true, and that issue was never decided by the court.
I think,
It doesn't have to be again.
I think it is true. I think that he has discretion on whether to enforce it. If he decides not to enforce it, this board does not have jurisdiction to tell this man what to do. That's the Board of Trustees' job, okay? It's a political issue. It's not our job to be telling the zoning director whether to enforce. Now,
Well, I think we agree on this, that what you can do is simply determine that his determination was incorrect. I tend to agree with Mr. Matthews that you probably do not have the plenary power to order him then to cut down those trees, at which point, if he doesn't, then we go back to court as an abuse of discretion. But you clearly have the authority, and I think Mr. Matthews just said that, to make a decision as to whether his determination was correct or not correct.
Review the correctness, yes. I believe that's a reasonable interpretation of 51914A. And I'm not going to rehash why I think he's right, but that's the core issue of the subdivision. And the only reason I was emphasizing discretion was not to revisit the prior issues. It was to respond to Mr. Pucilli's comment about the zoning administrator's role. His role is discretionary, under the code and under your code. But
I would point out, though, you are allowed to look at an abuse of discretion in rendering your decision.
now that, by the way, there's no case law on at all. The case law under 51914A is a clear standard of review of correctness. It doesn't speak to abuse of discretion, it doesn't speak to weighing of evidence, it's correctness, the correctness of the decision. Was he right in saying that 25 or 30 feet pine trees are not shrubs and thus not hedged? That's what we're talking about tonight. I don't want to belabor any further, but if you have any additional questions, I'm certainly willing to answer. Mr. Pucillides, did I answer your questions? Thank you.
Any further questions from the board? No?
None here.
Not, the chair will entertain a motion with respect to this particular appeal.
I'll make a motion, Mr. Chairman, again. Whereas applicant Denise Armitage,
Correct.
thank you, sir, 7690 Bucknell Circle Northwest in North Canton, Ohio 44720, parcel number 55-02504. Applicant requests an appeal in regard to the decision of the Plain Township Zoning Department relating to the application of Article 6, Section 602.10 of the Plain Township Zoning Resolution to grant the following. Section 602.10 fences, walls, hedges, or modify application.
Excuse me, may I ask if you're allowed to take this under consideration? Because one of the things I have asked and submitted into evidence is the videotape for the zoning commission.
We should have a second before we. And I think the other problem we have here is that
Makes sense.
We'll clarify.
well, that's the reason why I asked
Yeah.
that question, what is this, what are we here for? And if it's, in my opinion, if it's to tell the zoning director to enforce the zoning code, my vote's gonna be no. Because I don't think we have jurisdiction to do that. So I think it does matter,
Well, let's clarify the motion.
the motion.
Let's clarify the motion, please, before we hear a second one.
Well, to clarify the motion, are we voting on whether or not section 602.10 fences, walls, and hedges? Or are we voting on to request an appeal? And we say no to requesting the appeal. To not grant the appeal.
Okay. You need to clarify the motion with respect to the appeal that was made. Whether you're going to grant that appeal. And that appeal specifically was that Mr. Ferrara was incorrect in his determination as to the height of the fences.
Fences, walls, and hedges as they
relates
pertain to
the tree.
section 602.10.
Or more specifically, whether they're hedges or not, whether the trees constitute hedges.
His determination is that the trees do not constitute hedges.
Correct, that's his determination. I'm asking you to rule that his determination is incorrect. Not to order him to cut down the trees, just specifically say his determination was incorrect and that he abused his discretion. He had a conflict of interest because he was being sued. He didn't defer it to anybody else. He's never come out to the property to look at anything. To me, that's an abuse of discretion. I think that should overturn his determination.
Okay, so we have clarification on the motion. Make sure we get the motion down before we hear a second. Mr. Wright?
Yes.
We'll clarify it after hearing all
Did Mr. Ferrara, I'm having a difficulty with this one. Fail in his duty to determine whether or not trees were hedges and/or fences or walls.
Was his determination correct
Was the determination correct?
in determining that the trees are not hedges under the statute?
Correct.
Taking into account all the things all the irregularities I've listed. Because how can it be correct if he never came out of the property? I heard that. Do you have something more to say? Do you have a problem with something?
If you'd like, I could say what I
You
wanted
do.
to say, what I was speaking to my colleague about. The record is these are trees. Why would he need to go out when your own letter starting the matter said they were densely packed,
that. We'll seek your
25-foot
assistance
pine
relative to
trees?
the specific motion so that it is
Okay.
properly framed before the board,
Sure.
so that we can basically have the proper motion that is presented before the board.
Agreed.
He has perhaps offered a suggestion on his proposal. My proposal would be that it simply deny the appeal and find that the determination of the zoning administrator was correct. That way there's no ambiguity in which way you're voting.
And there is a third alternative that you take under advisement and not vote this evening. Because I think there's a lot of evidence and new evidence to consider.
So the reframe motion, if you want to make that motion, Mr. Reichel, you made it. It's essentially a motion to deny the appeal of the applicant, Denise Armitage, that was submitted to the Board of Zoning Appeals, and find that the zoning inspector's decision was correct.
So to grant the following or not?
Just how I stated it.
Okay. To deny the appeal of Denise Armitage, motion to appeal, and that the zoning inspector is correct in his decision.
Well, that's not the appeal I brought you. I'm the one appealing this, not him.
The motion that is presented before the board is essentially to deny, this is a motion to deny the appeal that you brought before the board on, I believe, June 11th of 2018. That was the letter. The appeal was received on June 28th, 2018. And essentially your appeal provided that the zoning director was incorrect in his determination that was submitted to you. You submitted that appeal on June 28th. So the motion is to deny that appeal and make a determination that the zoning inspector was correct in his determination. So that's the motion.
I will second that.
I need to have that motion. That didn't sound right.
I'm going to withdraw my
Let
motion.
me withdraw the motion. Let me
I'm
think.
going to withdraw my motion.
Okay, let's have a vote on withdrawing the motion, make sure this is done right. So we have a motion to withdraw the motion by Mr. Reichel. I'm seconding that motion. Let's have a vote to withdraw Mr. Reichel's motion.
Mr. Sutton,
Yes.
Mr. Pucillas.
Yes.
Mr. Reichel,
Yes.
and Mr. Solz.
Yes.
Okay, give me a second.
May I respond to what Mr. Matthews just said? Or should I wait?
No, go ahead.
I think you made the point that because my motion, or excuse me, my complaint says trees, that's a done deal. Again, as I indicated, the question is not trees, it's what says hedge. Trees qualify as a hedge, and again, as I've indicated, even if you want to accept the new definition, what's in my backyard on the Mazur's property line falls within the definition of shrub.
Right, I think
It's their definition, not mine.
what I heard here and what the appellant had made clear, that this was the zoning director's failure to enforce the zoning code 60210. I'm going to make a motion to approve the appeal that the zoning director failed to enforce the zoning code, section 60210. Again, it's a motion to approve the appeal that the zoning director failed to enforce the zoning code 60210. So a yes vote would be for the appellant to approve the appeal, and a no vote would be against the appeal. Again, it's a motion to approve the appeal that the zoning director failed to enforce the zoning code, section 60210. That's my motion.
Would you read it again so I can make sure we are all on the same page?
motion to approve the appeal that the zoning director failed to enforce the zoning code 60210.
Mayor, second. Second, anyone? I will second.
And again, my position is I'm going to vote no, because I do not believe this board has jurisdiction based on what I said previously.
That's a different determination as to the grounds for the appeal. So a motion to approve the appeal, a yes would be that the zoning director did fail to enforce the zoning code as provided for by Mr. Arliss in his testimony. A no vote would be that the zoning director did appropriately enforce the zoning code.
That's your interpretation. I'm saying, that, and I appreciate that, but I'm saying we do not have jurisdiction. I'm voting no.
I thought we had concluded that you have jurisdiction, which, just let me finish, just to render a decision as to whether his determination was correct or not.
But that's not my that's not my opinion. I'm sorry, but I just really feel that way after doing the research and looking at it. I really don't believe the Board of Zoning Appeals entertains failure to enforce the zoning code. And we can couch it whatever
It's not a
terms we
failure
want.
to enforce, it's what's his determination, correct?
Every time you decide not to do something, it's a determination. I make the determination not to do something. It's still a failure to enforce. We can couch it whatever words we want. I really do not believe we have jurisdiction
So
here.
you're defying that, you're disagreeing with the 5th district?
I
Clearly.
don't think the 5th district says, I don't think the 5th district addressed what I'm addressing. It doesn't say anything about that. It does not address it.
So even though Mr. Matthews and I both agree that you can rule on the determination, whether he was right or wrong, you're not going to do that.
And this is just my opinion. It's not clearly, and I'm saying this clearly so that everybody understands just my opinion, not the opinion of the other three gentlemen up here.
So this is like the only thing we've ever agreed on with Mr. Matthews, and we're not going to go with that.
Again, if this would help, Mr. Kouzalides, and I respect your position on this, and I think the board would have the authority to determine its jurisdiction, albeit with reference to the code. Maybe you could vote on that issue first. Entertain a motion to accept jurisdiction of the appeal, see where that vote goes, before you get into the substantive vote, and only reach the latter if you pass the form.
Are you permitted to consult with legal counsel on this issue before you make a decision?
I'm not their legal.
No, I'm not asking you, no, I'm not saying that, I'm not saying you are. I'm saying, do they have the right just to postpone this and consult with your legal counsel and then reconvene?
You will withdraw your motion to jurisdiction.
This is a jurisdictional motion.
Well, I would say we withdraw your motion, we can vote on the jurisdiction,
Okay.
and we can reconvene whether or not we want to entertain a motion. Final motion to table it.
We table the motion.
Table it.
I have no objection to that.
That's what
I guess that's something to do. Well, yeah.
Can I make a suggestion, you simply table it to consider the new evidence and then confer with your counsel? Would not be Mr. Matthews in this case. You know, do we really want to just leave here and go back to court and fight all this out? Because after 2 years, you determine you don't have jurisdiction, even though the 5th district said you did?
It doesn't, the court doesn't say that.
It does say that.
No, it doesn't say
It
that.
says based on the form, this should have gone to the Board of Zoning Appeals because they have jurisdiction.
It doesn't say the word jurisdiction does not appear in, I don't see it in this opinion.
When did you become a strict construction? I mean, you know, I got bounced because I should have gone to the Board of Zoning Appeals, and now you're telling me, no, you shouldn't be here. I mean, it's a catch-22, I have no place to go anymore.
Well, you can appeal it in the Court of Common Pleas.
I can appeal what you're doing,
Well,
you
yeah, I
really
know,
want me to do that?
and our position though, see, the Board of Zoning Appeals, we're not the same as the Court of Common Pleas. We don't have the same powers. They could make determinations, was what I'm saying. We can't, I mean, in my opinion, we can't, but that doesn't mean you cannot appeal, go to the Court of Common Pleas and have them make that determination, which I think would be the appropriate body to make that
I think
determination.
they've already made it, I think they're gonna defer to the 5th District, and we're gonna be right back here.
Good. I'll make a motion to withdraw my motion.
Withdraw a second.
We need a vote.
Mr. Posolidi, I'm sorry, Mr. Sutton,
Yes.
Mr. Reichel,
Yes.
Mr. Posolidi.
No.
And Mr. Schultz.
Yes. Now, the chair will entertain a motion if anyone wants to table this appeal for further discussion or a motion relative to jurisdiction.
I'll make a motion to table this appeal.
I'll second it.
Roll call vote.
Mr. Sutton,
Yes.
Mr. Reichel,
Yes.
Mr. Posolidi.
Yes.
And Mr. Schultz.
Yes. Okay, appeal's been tabled. Thank you.
Good evening.
Motion to adjourn.
So moved.
Second.
All in favor?
Aye.
I guess that's a draw.